everybody. Welcome to today's presentation, Long-Term Financial Planning, the who, what, when, where, why, and how. My name is Ryann Siclari. I am an attorney with the law firm of PORZIO, BROMBERG, and NEWMAN, and I am joined today by my friend.
Hi, everyone. My name is Steve Gruzlovic. I'm an advocate and board president for Progressive Center for Independent Living, along with many other titles and distinctions. We understand that this is a self-direction conference, which means that individuals with disabilities are able to make their own choices with or without support if they need it in virtually all aspects of their life. So we wanted to talk about financial planning and why that's important, and also why it's important to surround yourself with a team of people that can help you at times. So the first is the who are we referencing? It's people with disabilities who have or may need government benefits, or families of people with disabilities. I can make a lot of the decisions myself, but when it comes to complicated matters like this, I like to surround myself with people to help me to make decisions. So that's why, I contacted Ryann so that she could help me with these sort of things. And we also want to make a point before we get into why or how you would do this. There's people in society, Hollywood celebrities like Kim Kardashian, Stephen Hawking, other members of society that are well off or wealthy with disabilities. They're not necessarily going to have to worry about long-term financial planning like this. But for the average person in society just trying to make a way on government benefits, you're going to have to worry about these sort of things. Also, a big thing that we see is family members that want to leave money to other family members when they pass away. And we're going to talk about how you do that within this presentation. So when we talk about long-term financial planning for those with disabilities and their families, we're talking about items such as qualified income trust, or QIT, and other resources such as the ABLE account and the special needs trust. These are specifically geared toward people with disabilities, and these are what you would typically use in order to, shelter the assets.
So I'm going to take it over from you here for a little bit, Steve. So the qualified income trust only deals with income. When we're talking about a QIT, we're talking about income, not resources. So we have to kind of bifurcate these things in our mind. And so the QIT really is only required in some narrow situations. It's only necessary for individuals whose income exceeds the income cap, which right now is $2,523 a month. And that changes annually. So that's the 2022 number. But even then, a QIT is only needed if that person is seeking eligibility under two particular Medicaid waiver programs: Managed Long-Term Services and Supports, or MLTSS, or the Supports Program. So in other words, if your income is below the cap, you don't need a QIT. If you aren't applying for MLTSS or the supports program, you also don't need a QIT. So the situations in which someone would have a QIT is actually quite narrow. But for those who do need the QIT, the purpose is simply to make the income not count for eligibility purposes. So the way it works is a person would deposit the entire income source into the QIT, and Medicaid won't count that income towards that cap. So now it doesn't need you to keep that income and spend it on what you want. They still require that it be spent every month on authorized expenses like your personal needs allowance or your health insurance premiums if you have a private policy. But it allows a person who would otherwise be disqualified because their income exceeds this cap to be eligible for the Medicaid program from an income perspective. So to the extent there's income left in the QIT at the end of the month, they would require, that would be considered a resource. So when we're looking at this, we're thinking solely in the income box. But then we have other tools to help us deal with resources. One of those tools is the ABLE account, which stands for Achieving Better Life Experiences. And that was based on a law that was passed in 2014. And it allows for a person with disabilities who's over the age of 18 and has capacity, or a parent, guardian, or a power of attorney to open an account if the person with disabilities meets certain criteria. First, their disability onset must have been prior to the age of 26. Even if that person is not determined disabled until after 26, if their disability onset was prior to the age of 26, that's enough. So if someone develops their disability later, for example, schizophrenia often presents itself in someone's late 20s. That person, if their disability started at 27, 28, they would not qualify for an ABLE account, even if they're currently disabled, because the onset wasn't prior to the age of 26. So that's the first criteria. The second criteria is that the person must be receiving SSI, Supplemental Security Income, or SSDI, Social Security Disability Income, from the Social Security Administration. If they're not receiving it, there is an alternative where they can obtain a certification from a physician confirming that the person's disability is marked and severe and started prior to the age of 26. So if the individual is eligible and they open the ABLE account, what can go in the account? Well, either or both, really, the person with disabilities or others, so family members, strangers, I can put money in Steve's account. Anyone can contribute to an ABLE account for a disabled person. However, the maximum annual contribution is tied to the annual gift tax exclusion, which is currently $16,000. So for 2022, the maximum contributions combined, so my contribution, the next guy's contribution, Steve's own contribution, add them together in 2022, they cannot exceed $16,000. There's one exception though. If the person is working, they can also, so in addition to the $16,000, they can contribute their earnings up to 100% of the federal poverty level, which is $12,880 for 2022. So there are some limitations there if you also contribute to a retirement account, but that's the general rule. So the income that is contributed still counts as income. So with the QIT, the income didn't count as income. But when you contribute income to an ABLE account, SSI and Medicaid still treat it as income for eligibility purposes. So we're not using the ABLE account as a way to reduce our countable income. It's just a way to prevent that income from accumulating and creating a resource issue. So we have to, again, bifurcate the income rules and the resource rules in our head. So that's one way that an ABLE account is different than a QIT. So if the person is receiving SSI or Medicaid, the ABLE account is not counted as a resource. So for example, my checking account is a countable resource, but the ABLE account is not, but only up to a maximum of $100,000. So for example, if the person had $105,000 in their ABLE account, they would be disqualified from SSI because the $5,000 over the $100,000 limit counts as a resource. And now you have more than $2,000 of resources and you're disqualified from the program. So it's important to keep that $100,000 resource limit in mind with the ABLE accounts. So what can the money in an ABLE account be used for? Well, it can be used for any qualified disability expense, which is actually pretty broad. So unlike special needs trusts, which we're going to talk about in a minute, you can use ABLE account funds for food and shelter without a reduction of your SSI. So you can use the money for education, transportation, assistive technology. It's very, very broad as to what you can use funds in an ABLE account for. So you're probably like, oh, this sounds great. What is the downside? Well, the downside is the payback provision. So upon the death of the person with disabilities, any funds remaining in the account are used to pay for any outstanding qualified disability expenses. So for example, if the person needs a funeral after they pass away, you can use ABLE account funds to pay for that, which is a departure from the special needs trust that we'll talk about in a minute. But after those remaining qualified disability related expenses are paid, the money that's left goes to the government. So it goes back to Medicaid to pay for the benefits that they paid during the person's lifetime. So if there happens to be any money after the government is repaid for benefits, then it would go to the person's estate. I'm going to turn this one back over to you, Steve.
Okay, so next we're going to talk about special needs trust. Which a special needs trust is intended to preserve eligibility for means-tested government benefits programs such as SSI and Medicaid. Such programs limit the amount of resources that the beneficiary can own and the amount of income that he or she can receive. The beneficiary's receipt of income or the provision by the trust funds of food or shelter can adversely affect eligibility for such programs. So there's rules associated with this too. It's meant to provide aspects for the special needs of the beneficiary with disabilities so that the beneficiary can live a more productive and comfortable life. They can avoid having trust assets count as a resource to the beneficiary and avoid having trust distributions count as income to the beneficiary. And also for this type of account, you need a trustee and they must administer a special needs trust with constant consideration of the resource and income limitations. So this is commonly used. There's a first and a third party trust. This is what people commonly use to leave money to their disabled loved ones, as well as they use this for accident claims and other types of settlements as well.
Yeah, so when we're talking about special needs trust, there's different types. So when you hear the term special needs trust, it could be one of a few different types of trusts. So we kind of need some more information a lot of times to figure out what we're talking about. So the first kind of trust, I call it primarily a first party special needs trust, but it's also known as a payback trust, an OBRA 93 trust, that's based on the law, D4A trust, a self-settled special needs trust, tomato, they all mean the same thing. It is a trust that is funded with assets that belong to the person with disabilities. A pooled special needs trust is very similar to the first party special needs trust. The biggest difference, though, between those two is who controls the money. So in a first party special needs trust, the trustee who is appointed manages it. For a pooled trust, it's actually a corporate nonprofit. Plan NJ is who we use here in New Jersey to run the pooled special needs trust. Then there's the third party special needs trust, also commonly called a supplemental benefits trust. That is a trust in which is funded with money that belongs to someone other than the person with disabilities. So the easiest way, I say the easiest, but you'll see it's not quite so easy. The easiest way to figure out which type of trust you have is to see whose money is funding that trust. So we'll get into that in a minute. I'll come back to that. So when we talk about the trust, it's important to first understand the roles or the hats, the different hats that people involved with the trust wear. So the grantor is the person who creates the trust and who funds the trust. So with a first party special needs trust, this is the person with disabilities. With a third party special needs trust, it is someone other than the person with disabilities, such as a parent or grandparent. That can be a little bit deceiving, though, because a first party special needs trust can be established by the disabled person, a parent, grandparent, guardian, or court. So the grantor, though, is still the person with disabilities because it's their money that's funding the trust. So the trustee is the person who manages the money on behalf of the person with disabilities. Unlike an ABLE account, where the person with disabilities can really control their own money, they have to appoint someone else to be trustee. They cannot be trustee of their own special needs trust. Then the last hat or role that we have is the beneficiary. And the beneficiary is the person who benefits from the money that's in the special needs trust. So as I said, with a first party special needs trust, it can be established by the individual, and that's actually kind of new. It's only from 2016. Prior to that, a person with disabilities could not establish their own special needs trust. It was kind of amazing, actually, that a person could not establish their own. But now, as long as the person has capacity, meaning they understand what they're signing, they can establish their own special needs trust. But in the event they cannot, it can still be established by a parent, grandparent, guardian, or court on their behalf. So as I previously mentioned, it's funded with money that belongs to the person with disabilities. And it's not so easy sometimes to figure that out. So for example, an inheritance. If my parent passes away and they leave me money, whose money is that? Some people might say, oh, well, it's clearly the parents because they're leaving it to you. Well, at the point that they've passed away, if they leave me money outright, their will says $100,000 to Ryan, with nothing further in the will, that's my money. They've passed away. That is vested in me. It is my money. So I would need to establish a first party special needs trust, not a third party, because it's too late. They've passed away and it's vested in my name. So that's a situation where it looks sticky from the outside. So you've got to be very careful when identifying who the money belongs to. Similarly, personal injury settlements, right? That's money that belongs to the person who was injured. So why would I say to you, let's put the money in a special needs trust? Well, we put the money there so it doesn't disqualify the person from means-tested government benefits. And the law allows us to do it without penalty. So if I get that $100,000 inheritance and I'm on Medicaid, Medicaid's going to say, get out of here. You have too much money. You're not eligible anymore. But if I put my money into a first-party special needs trust, Medicaid says, you're allowed to do that. We'll let you do that, and it won't count, and you still get to keep your government benefits. So that's why we have this device known as the first-party special needs trust. But there are limits, right? We can't do this forever. There's a age 65 limit when it comes to establishing and funding, meaning when I actually put the money in the trust, you have to be under the age of 65. And the reason for that is really because this tool is meant for people with disabilities, not people who are aging and need nursing home care through Medicaid. So I think that is the reason they've put this age limit on here, is to prevent people who need nursing homes from funding a special needs trust because of age-related issues, from funding a special needs trust in order to get eligibility. So you got to create it and fund it prior to the age of 65. There's one exception, and that's related to structured settlements and alimony. So let's say you did get a personal injury settlement, and instead of them giving you a lump sum, they did a structured settlement. You could irrevocably assign that structured settlement to the special needs trust. And that would, even though deposits are made after the age of 65, as long as the irrevocable assignment is done prior to the age of 65, you're good. So that's one exception, a very limited exception to that age 65 rule. So this age is really, really important because, especially with the changing workability legislation, I know, Steve in particular was really vital in getting that workability legislation passed. So if anybody doesn't know about it, it really broadens the eligibility criteria for workability Medicaid. It's amazing legislation, but it's not active yet. So just keep that in mind. But when it is active, one of the things that it does is it limits, it expands the ages, right? We no longer say you're kicked off at age 65. So someone could feasibly remain on workability till age 70. So age 70, they're like, oh man, I'm really tired of working. I want to retire. They retire, they're no longer working, which means they're no longer eligible for workability. But now they have to look towards other Medicaid programs, which have resource limits. If they've been working and saving under workability, they turn 70, retire, and look to other Medicaid programs, and now they have too many resources. They can't fund the special needs trust anymore because they're already past the age of 65. So one of the things I would say to you as one of the many takeaways from today is, even if you don't need a special needs trust now, it's something you should evaluate prior to turning age 65, because the minute you turn 65, it's no longer an option. So I would encourage you to at least evaluate the need for it if you're approaching that 65 mark. So the last part of the special needs trust that's really important is the payback provision, very similar to our ABLE account, but a little bit more stringent actually. So any funds remaining in the trust at the death of the beneficiary must be repaid to Medicaid and DDD for all expenditures they've made over a person's lifetime. You cannot pay for anything once the person's passed away. So, for example, you didn't purchase an irrevocable prepaid funeral. The person has passed away. You cannot use the special needs trust funds to do a funeral.
And I just learned about the irrevocable prepaid funeral the other day. And this is a great option for people to use the money, so that it doesn't go back. Because once the individual with disability dies, that money goes away in the first party special needs trust. It can't go to heirs. It can't go to a charity that you want it to go to. It can't go to nieces and nephews and brothers and sisters. It goes to the government.
Right.
And I would start planning for that. It sounds morbid, but I would start planning for that and sitting down with people for that prepaid funeral now.
Yeah.
Most funeral homes are very familiar with this sort of thing.
Yeah. So from a procedural, like, what would you do? You'd literally call the funeral home and say, I need to set up an irrevocable prepaid funeral for Medicaid purposes. You would literally go there, pick out the casket and all of the things that go along with it. It's very bizarre, but then they'll give you a list of services. You would submit that to Medicaid, because one of the other things about the first party special needs trust is if it's a transaction over $5,000, you have to give Medicaid 45 days notice. So you submit it to Medicaid, say, I want to purchase this irrevocable prepaid funeral. Here's the contract, here's the services. They'll approve it, you purchase it, and now you don't have to worry about that. And because the downside is if you don't do it ahead of time, they cannot use the special needs trust money and someone else is having to pay for your funeral. So there's no downside to doing it ahead of time, other than it being weird.
Yeah.
So the upside of the special needs trust is very clear. It allows you to maintain eligibility for benefits that you absolutely rely on. But the downside, in addition to the payback provision, is that it's super rigid as to what you can use the funds for. So all distributions from the special needs trust must be used for the sole benefit of the disabled person. And that can get a little bit hairy. So what happens if the trust owns a piece of property and people other than the person with disabilities live there? Well, in order to not violate the terms of the special needs trust, which require that the trust assets be for the sole benefit of the person with disabilities, the other people living in the house have to contribute their pro rata share of the expenses in order for it to not be a violation of the terms of the trust. And Medicaid will ask, right? You have a house that's owned by a trust and other people live there. Medicaid's going to say, hey, knock, knock, knock. Where are your pro rata contributions? So if there are 4 people living in the home, the trust can only cover 1/4 of the expenses in order for it to qualify for the sole benefit. So these are just nuances that you got to be aware of. And again, the trust can make distributions for the beneficiary's special needs that supplement, not supplant, i.e. replace the government benefits. So in other words, if it's not covered by the government benefits, then the trust can pay for it. So the trust can pay the cell phone bill directly, the cable bill, can buy video games or athletic equipment or trips or movies. The things that can become problematic from the trust are really food and shelter and cash. Those are the 3 hot button problems when we're talking about special needs trusts. So with an ABLE account, there's no problem paying for food and shelter. Doesn't cause us any issues. But with a special needs trust, if it pays for food or shelter, so rent, for example, there is a 1/3 reduction of the individual's SSI or the actual cost if it's less than 1/3. So there are certainly times where it makes sense for a trust to make these payments and receive that reduction of SSI. But I would just recommend to you that you consult with someone who understands the interplay of all the government benefits before making distributions for food and shelter. Because if you have a reduction of the SSI and there's other income that reduces the SSI, you may inadvertently get terminated from SSI. So it's certainly something where you need to have it evaluated before that determination is made that this is a distribution that qualifies under the terms of your particular trust and doesn't jeopardize government benefits. As to cash, that is income. That is, cash distributions are income to the person with disabilities and can certainly kick them off government benefits entirely if it results in their total income exceeding any eligibility limits. So cash is one of those hard and fast rules. Don't distribute cash to the beneficiary. It can truly jeopardize their eligibility. So as I had mentioned earlier, distributions over $5,000 you must give Medicaid a 45 days notice so that they can either object and give you the opportunity to appeal, or they can say, we have no objection to you purchasing X, Y, or Z, that it's above $5,000. Lastly, because Medicaid has a vested interest in how the trust is spent, because anything that's left goes to them, they do require an annual accounting of the special needs trust. So they want to know, how'd you spend that money? And they will audit it and look at all those transactions and ask for receipts and show that you followed the rules. So it's very stringent compared to other types of trusts. So now we're going to shift gears to the third-party special needs trust. So this is the trust that's funded with money belonging to someone other than the person with disabilities. So listen up, family members of people with disabilities. If you wish to make gifts or leave an inheritance to a person that has disabilities, you need to leave it to them in a third-party special needs trust. So going back to my inheritance example, if my parents leave me an inheritance outright, I got to go put it in that first-party special needs trust that has that terrible payback provision and all those rules. If my parents leave it to me in their will in a third-party special needs trust, guess what? It's a lot more flexible and there's no payback provision. So the benefits, no payback provision. So to the extent funds remain at the death of the person with disabilities, they will go to whomever the person who created the trust selects. So let's say I create a trust for Steve. I'm going to leave Steve $100,000. Congratulations, Steve.
Wouldn't that be nice? I'm waiting.
I know you are. So I leave Steve $100,000 in a third-party special needs trust. I would say in my trust, to the extent any money remains at Steve's death, I want it to go to my favorite animal charity. I can do that with this type of trust. I couldn't do that with the other type of trust. So it goes to whomever the person who creates the trust selects, not Medicaid. And you don't have to account to Medicaid or ask their permission for distributions from this trust. You still have to be aware of the rules surrounding the distributions, right? So we don't want to make a distribution that affects the person's benefits. So we still have those concerns about the food and the shelter and the cash, for example. So we still have rules. It's not a free-for-all, unfortunately, but it's a lot more flexible and you get to ultimately leave the money to whom you want, not the government. Back to you, Steve.
So the next thing we're going to talk about is when to establish a special needs trust for these type of accounts. If you're a family member of a person with a disability, the answer is it's never too early to do this. As we stated before, if you don't do this and you pass away and the money goes to them outright, they either have to establish a first party special needs trust with all those restrictions and conditions, or they can't take it. Personally, myself, my grandpa left money to all his grandchildren. I told him that he needed to put it in a trust account. Okay, this was the time when COVID first started. He contracted COVID and eventually passed away, but didn't leave the money in the trust. He actually had a meeting to go to his trust attorney a couple days, after he went in the hospital, but he never made it. So I wasn't able to accept the money. So I think it's really important that family members, and you want to do the right thing to make sure that the individual with disability is taken care of. That is a lovely, wonderful thing to do. But when they are on government benefits, you have to make sure that it's done in the correct manner. The other thing is a change in circumstance. So inheritance from a family member who did not leave it in a third-party special needs trust, like we talked about before. If you get a personal injury settlement, you should establish one. And before you turn 65, because the magic cutoff of your 65th birthday, and savings where you have an onset of disability and you're going to eventually need government programs. Like we said earlier, if you have a case where you're Stephen Hawking and you don't need government programs to help you, then that's great. That's wonderful. You can use your own money and not have to worry about it. But for the average population, you need to set things up in a way so that your loved one is taken care of.
Okay, so where can you go to establish these things? So the Qualified Income Trust is available online, actually. So the state of New Jersey has issued a template document that people can use to establish their QITs. But with that being said, I highly recommend that you consult with an attorney, because if the QIT is not perfect, it will give Medicaid a reason to deny you. So I would just say that where you find yourself in a situation where a QIT seems like the right option for you, you should consult with a lawyer who specializes in elder law and disability law to make sure that it's done properly, even though this is an available thing. But if you want to see what it looks like, it is an available template online. For ABLE accounts, New Jersey does now have its own site for establishing ABLE accounts, but you don't have to use New Jersey's. You can actually establish an ABLE account in any state that you want, but the rule is you can only have one ABLE account. You can't have multiple ABLE accounts.
Yeah, we advise that people look at the different states' general, what they're offering people and make the best decision for your specific situation, because each state offers a different type with different provisions in each one.
Exactly. The Special Needs Trust, unfortunately, that's not one that you can generally draft on your own. You do need to speak with an attorney to have a Special Needs Trust drafted. My personal, maybe I'm biased, I recommend a certified elder law attorney. I am one of them, so I maybe that's why I like them, but somebody who has a specialty in this area is critical, because if you have somebody who can draft a special needs trust but doesn't necessarily understand the interplay of all the government benefits programs, it may not be the best result for you. So I would certainly recommend a specialist in the area. Another resource where you can find specialists is the National Academy of Elder Law Attorneys. There are websites for both of these organizations. You can certainly go on there to look for an attorney in your area who might be able to assist you with drafting these things should you need it.
And why do we do this? We do this because we have to maintain government benefits. Supplemental Social Security or SSI, Medicaid, which program, Division of Developmental Disabilities. You have to have Medicaid and be Medicaid eligible for DDD. So that the people that have the supports budget that get all their services or a significant portion of the services taken care of by the state, you have to have Medicaid to be eligible for DDD. And if your Medicaid gets taken away or there's a lapse in Medicaid, they will pull your funding from DDD. So it's very important you secure that at all costs.
So with that, it's important to understand the income and resource tests that go along with the programs that you're on. So that way you don't inadvertently run afoul of those things going forward.
So how do you do this? Like we said before, you don't wait. You start consulting now. Even if you have small children that are still in school, you start talking about all this now. I understand it is a difficult conversation to have with relatives and loved ones, okay, about passing away and setting stuff up for the future. It's an uncomfortable conversation, but if you can have that conversation and set things up for the future, it makes it a lot easier. Also, you want to consult with an expert who can apply your financial situation to the rules of the program. This is not something you want to Google and try to do yourself. Obviously, go to Google and do some research, and everybody's financial situation and what their goals are for their life are a little bit different. So you need to consult with an attorney or an expert that will, be able to advise you how to do it for your specific situation. And also with that, using the right tools for your situation, whether it's a qualified income trust or a special needs trust, first or third party, or the ABLE account, you need to be able to use the right tools within your toolbox for the actual situation. And part of doing that is to sit down with an attorney who can help you. Because if you try to do this yourself, it's going to get really confusing, and it could be detrimental, and you can cut all your services off.
So to summarize everything that we talked about today, who are we talking about when we're talking about long-term financial planning? People with disabilities or their family members. What are we talking about? QITs, ABLE accounts, special needs trust. When? If you're a family member, we're talking about now, right? We don't want to wait because we don't know what the future holds for us. If we're talking about a person with disabilities, often we're looking for a change in circumstance, whether that's a inheritance, personal injury, maybe the lottery, who knows, right? Where can you go? You can go to the ABLE account website. So you can go to the QIT website. You can consult with an elder and disability law attorney. Why do you do this? To maintain or obtain eligibility for means-tested government benefits. And how do we do it? We use the tools that are right for you, and they are not the same for every situation. So we appreciate you coming today. Steve, it was wonderful as always to present with you.
It's wonderful to present with you as well.
And we look forward to taking any questions. Thank you.